All right, welcome. Today, we are putting a brand new law, HB 8002, to the ultimate test. We're going to run it through what you could call a legal gauntlet, a series of checks and balances that are baked right into the U.S. Constitution. So the big question is, does it hold up?
So, here's our game plan for today. First, we'll cover the big, ultimate test every single law has to pass. Then, we'll dig into this incredible 230-year-old rule that's really the bedrock of our whole legal system. After that, we'll see how this bill stacks up against our national rights and state-level safeguards. And finally, we'll tackle a really important question. What's an official's constitutional duty when a law seems to clash with the Constitution? Okay, before we go any further, I want to be really clear about something. What we're doing here, it's not about politics, it's not about taking sides. We are simply applying settled constitutional doctrine. These are the rules that have guided American law for over 230 years. This is all about the law itself, not anyone's opinion on it.
All right, so let's get into it. Every single law, no matter how new or how well-intentioned it might be, has to answer to the Constitution. So what actually happens when a brand new piece of legislation like HB 8002 goes head-to-head with these old foundational rules? Well, that's the ultimate test, and that's exactly where we're going to start. Okay, let's dive into the single most important rule in this entire process. Seriously, this is a principle that goes back over 230 years, and it's the foundation for literally everything else we're going to talk about.
And there you have it. Acts repugnant to the Constitution are void. That's the bedrock right there. It means that if a law goes against the Constitution, it's not just a bad law. It's legally null and void. It has no power. It confers no authority. Full stop. This whole idea has a name: constitutional supremacy. You can think of it as the ultimate rulebook. No other law, doesn't matter if it's from Congress or a state legislature, can break the rules in this book. The Constitution is the supreme law of the land. It's the final word. And just to be clear, this is not a new idea. Not at all. I mean, look at this timeline. It shows a totally unbroken chain of court decisions going all the way back to the beginning of the country. From way back in 1795, through the huge case of Marbury v. Madison, and right up to the Civil Rights era, the Supreme Court has said the same thing again and again and again. The Constitution is supreme.
Okay, so now that we've got the ground rules down, it's time to run HB 8200 through the first part of our gauntlet. And that's the big one: the U.S. Constitution and the Bill of Rights. So first up, we have the First Amendment. This is all about your freedom of expression. It protects your right to speak your mind, to assemble, and to petition your government. So if you disagree with a housing initiative, or any policy for that matter, you have an absolute, constitutionally protected right to say so. Any kind of retaliation or attempt to shut down that debate, well, that's just unconstitutional.
All right, next up is the Fourth Amendment. This is all about property protection. The government can't just compel you to map out your private property or subject it to surveillance. Your home, your land, they are supposed to be untouchable without a lawful process or your voluntary consent. It's that classic idea: your home is your castle.
Okay, now we're getting to a really crucial one, especially when you're talking about land use laws. It's the Fifth Amendment, specifically the Takings Clause. This is really where the rubber meets the road for property owners.
So check this out, because it's a super important distinction. We're talking about regulatory takings here, and they can happen two ways. Either a legislature passes a law or an administrative agency makes a rule. But you know what? The Supreme Court says it doesn't matter. Both are still considered takings, and if it happens, they require just compensation.
And if you're wondering if this is still a big deal, well, take a look at this. This quote is from a unanimous Supreme Court decision from just this year, 2024. The court made it crystal clear: the Takings Clause applies to laws themselves, not just some discretionary permitting decision. This principle is alive, well, and being enforced right now.
But wait, there's more. The protections just keep coming. The Seventh Amendment, that preserves your right to a jury trial if you have a property dispute. The Ninth says, hey, the rights listed here aren't the only rights you have. And the 10th is a huge one for this topic. It says powers that aren't specifically given to the federal government, like local land use decisions, are reserved for the states and the people.
Okay, so we've run through the national part of the gauntlet. Now let's move on to the next level of safeguards, because it's not just about the U.S. Constitution. States have their own protections, and in this case, we're looking at what's written right into the Connecticut State Constitution. So in Connecticut, you've got Article 1st. Think of this as another strong layer of protection. It secures your inherent rights, it protects your property, it guarantees you due process and access to the courts, and, this is key, it prohibits creating privileged legal classes. Everyone is supposed to be treated the same under the law. And then you've got Article 10th, which is all about something called home rule. This is a really powerful idea. Basically, the Connecticut Constitution says that a town's powers should be interpreted broadly in favor of the town. The authority over local land use comes from the people who live there, and that authority can't just be pushed aside or coerced by some administrative agency.
Okay, so we've walked through all these constitutional layers, both federal and state. So what does all this legal doctrine actually mean for the public officials whose job it is to implement a law like HB 8002? What's their constitutional duty here?
Well, it really boils down to one thing, one single primary obligation that has to guide everything they do. And that one thing is their oath. The Supreme Court has been saying for a very, very long time that an officer's oath means they cannot enforce unconstitutional acts. It's not optional. It's not a choice. It is a fundamental duty of their job. So what does that oath look like in action? Well, it means three things. One, officials have to recognize that their authority isn't endless. It's limited by the Constitution. Two, the actual substance of the Constitution has to win out over any administrative process or form. And three, if someone's rights are infringed, there has to be a real remedy available through the legal system.
Really, what this all means is pretty simple. Government authority has to stay within the lines drawn by the Constitution. That's it. It has to stay within those prescribed limits. All right, let's do a quick summary of the key principles we've covered. First, government authority is limited. Second, just because authority is delegated doesn't mean it has no limits. Third, the real substance of the Constitution always beats administrative paperwork. Fourth, you can't just pass a new law that diminishes existing rights. And fifth, if a right is infringed, the law has to provide a way to fix it.
And that brings us right back to the big question we started with. Ultimately, what happens when a new law meets an old constitution? It's a tension that's at the very heart of our legal system. And the answer, which has been reinforced for over 200 years, seems to lie in the incredible, enduring power of those constitutional checks and balances. Thanks for tuning in.